Good afternoon, everybody. Welcome to the Lunch and Learn for Settlement Week. Judge Cook is running a little behind, so we're going to go ahead and start it. We are passing out some notes pages from the PowerPoint. Some of the text might be a little small on those pages, but you'll be able to hopefully read it here on the screen, or use a magnifying glass, use your reading glasses, whatever it is that you need. Magistrate Julie King has worked incredibly on this settlement week, and so she's going to be here and help us with the presentation. With her, a lot of the staff, family court services, especially Jeannie and LaTanya, have worked really hard, and everybody's kind of been working to try to get this together. So we thought it was best that there be a lunch and learn so that questions can be asked and we can explain the information. From my understanding, this is being videotaped and it'll be posted on the website. We'll also have the PowerPoint available on the website. And then at the end, we've included an email address. So if anybody has any questions after today, they can always email that to that email address, and LaTanya and Jeannie will be sure to answer those questions. So we're going to go ahead and we'll get started. We can advance to the next slide. This is just Summit County Domestic Relations Court. We are resolving family law cases peacefully and quickly. We're hoping with the very first settlement week that we have. From my understanding, Judge Cook had gone to Medina and had reviewed Medina's settlement week last year and decided she wanted to try one for our court. And so this is where we are. There she is. This is where we are today.
Sorry,
that's okay. I had you over here, but you can put me over there. I'll move my page.
No. I'll go over there. Hi, everybody.
So all I did was just introduce, and we passed out the PowerPoint. That's your slide there. So you're welcome to.
This is what happens when you have a pro se party and an attorney. Always extra work.
And I think the pizzas just got here, so you're welcome to jump in. This is just where we just started. Okay. I was just telling them about your vision for settlement week after going to Medina.
Thank you. Yeah, we also decided after talking with the magistrates that I already didn't want to get in the middle of their settlement week.
Just yeah.
Or you can
Just use the phone.
Okay. All right.
I didn't want to get in the middle of their settlement week, so first I was going to do it the week after, and then all the magistrates were like, no, hang on. We want to do it the week before them because with all the school stuff coming up, we're hoping that we can get a lot of that kind of stuff resolved before school starts, and somehow it's starting earlier and earlier. So by having it just a week before school starts doesn't mean that we're necessarily going to address all those issues. So that's the reason why it's the last week of July, if you wanted to know. Okay, so go ahead.
So settlement week is one of the things that is requested by the Supreme Court, that they would love for courts to be able to resolve cases through settlement week. We know the General Division in Summit County has done that for a number of years. And like I said, Judge Cook went and saw Medina's, I think their first one was last year.
Yeah.
And decided we would try it here. So this is directly from the Supreme Court page as to their reasons why settlement week is important. So first of all, from the Supreme Court, this is basically a court-managed program that reduces court backlogs by using mediation to resolve pending civil or domestic relations cases. And so essentially what happens and what is prescribed from them is that the court designates a specific time period, which can be a week or a few days, and selects cases for mediation based on recommendations from judges, attorneys, and parties in dispute. For those of you who've been involved in this process, that's exactly what we've done here. There you go. So these are the benefits from conducting settlement week. Again, some of this is from the Supreme Court and some of this is for what we put together. So essentially that parties have an opportunity to meet with somebody who's a trained mediator. All of the mediators here are trained. Many are the magistrates here to settle their disputes expeditiously. And they say outside of court, even though you're kind of in court, but you're not in trial. Saving the time and expense of trial helps us to reduce caseload and allows us to focus on cases which cannot be resolved except by trial. Did you want to address that last one?
I have one question.
Sure.
Are we neutral evaluators or mediators?
Well, there's two different, some are mediators, some are neutral evaluators, so that's coming up.
And we'll be talking about that. Good question, though.
You want to address that last bullet?
Okay, so it's our opportunity, yes. So years and years ago, telling a story, before my time, this is what I heard. I heard that, that when the idea of bringing a mediator here was broached with the DR bar, that the attorneys were a little nervous because they were afraid they were going to be losing their livelihood at the court. And so I believe an agreement was struck with the judges of the court and the Summit County Family Law Section to just do parenting issues. And so that's fine. I believe that mediation rule, local rule, I think it was from 2008. Well, I did look at it. It is pretty old. It needs to get redone. And so this is a chance to take us another look at what we're doing at this court and to see if we can do better. So that's what we're gonna do. This is the first time. That's why I didn't want to charge people for mediation or neutral evaluations, because this week is what I call amateur hour. So we're all learning this week. That's why I ask everybody to please, participate in exit review interviews or exit surveys. And as we go along in the week, if we could do better, we will. I wasn't here right at the beginning, but I just want to make sure that Julie King has gotten the credit that she deserves, because she's been putting together a lot of these forms, and we have a lot of people. You can get more. Yeah, absolutely. So we have a lot of staff that has been doing extra time, extra effort, spending lunch hours, and we're really on total overtime, trying to get this, overdrive, trying to get this done and to try to do it the right way. So just like I said, how they say, pardon our dust. So pardon our dust for settlement week. But we're going to take a good look at what we have been doing to see what we want to do in the future for our mediation.
So we thought these numbers would be interesting, that even though this is our first time, 84 cases were referred to settlement week, and of that, 8 cases are scheduled for neutral evaluation and 58 scheduled for mediation. As the cases are resolved, and if you have any cases that resolve prior to mediation, let us know. Judge Cook had a wait list created, so some have been resolved, some are rejected, and a few are on the wait list. But that, of course, is the potential for more than 350 participants. And we say more than, because it could be a lot more than that, depending on how many people are on each case. And so we're not sure how many we would resolve, but I'd like to see 84.
That would be nice. I know that Judge Fuller down from Delaware County, he brags about his numbers. So I would love to just be better as far as our settlement wait. I always love a good competition, good healthy competition. You know what I mean? And then it'll help everybody who comes to that court. So that would be great. I think he's at like 75% or something. I think he talked
Something
about.
close.
Yeah. So if we can do better, we will. I will say we have the capacity, like the $6 million van for you old folks. We can rebuild it. And so we have the capacity of doing at least, I think we counted with rooms and everything, 100 mediations. That's how we had scheduled it. However, our goal was only to each of us judges, to only basically try to refer 25 just to do half, because we just didn't want to have so much stuff going on that we weren't doing this first year right. So for us to be at, to be already over and then have a wait list is amazing. And last week, I will tell you that we actually had on 2 different cases, attorneys said, can we just put this in settlement week? And it was like music to my ears. So great to see, and we're looking really forward to see what the settlement week is. But just like I said, don't get nervous. We do have the wait list because back in the day when I used to be a mediator over at General Division, I remember I was a substitute mediator, and I get the call at home going, Katerina, you don't need to come in, they settled. So I think a lot of times parties and attorneys are like, oh, instead of going to settlement week, we're almost there, let's just do it ourselves. Please by all means, do it yourself, get it done. If you want to do it ahead of time, just let us know as soon as possible, because we have a wait list, and we'd like to put those people, plug and play those people in for those slots.
So that you're aware, there were cases that were rejected, and I believe, correct me if I'm wrong, most of them were rejected because of domestic violence. And so I don't know, I know you're going to be talking about the next slide, Magistrate King, but maybe you can explain. That's part of the rules of mediation, is that a screen has to occur. And so that's mainly the reason that most cases were rejected, I think. And this is for you.
Okay. So I am very excited about Settlement Week because mediation to me is just such a crucial part of family law issues. And even if parties can't come to a full resolution during Settlement Week, it plants the seed in their head to think about things, to think about options. So I was very excited when I was approached to help plan and execute Settlement Week. And again, this is the first time this court is doing it, so welcome feedback to see how things are going. It's an ever-changing process. What we're offering for Settlement Week are 4 different features. First being mediation, the second being neutral evaluation, the third being agreement express, and the fourth informal proceedings. So first with mediation, all of our mediators, whether they're inside, meaning magistrates or evaluators from Family Court Services, or outside mediators, all have training through the Ohio Supreme Court, Rule 16 of the Superintendent's Rules, to have basic mediation, advanced mediation in family law, as well as domestic violence issues in mediation. There's been a screening process, which Judge Hightower had mentioned, where our screening committee comprised of certain magistrates, thank you Magistrate Jay, Magistrate Jackson, and Renee Gosney-Shea. Yes. I know she's here, I'm looking for her. Helping screen the cases for domestic violence issues. Any cases that had active CPOs were automatically screened out. Also taking a deeper dive and looking at cases, whether or not it was appropriate, if there was coercive control, there wouldn't be a capacity or ability to mediate. Those cases would be screened out. And then also doing a conflicts check and going through the list and recommending certain mediators to be able to handle the case, and then the case got scheduled. So we have the bulk of our cases are mediation. We'll have a primary mediator. A couple of the cases might have a co-mediator depending on the issues, and we'll talk a little bit later about the process of what that mediation looks like in terms of checking in the day of and then after. With neutral evaluation, that's something new here to the court, and we're very excited about it. In talking to different courts across the state, Franklin County, Hamilton County, as well as Delaware County, neutral evaluation is something that's used to help parties reach resolution in a different way than mediation. And what it is a panel of neutrals who listen to arguments of the parties, 15 minutes each side, and then each party prepares a perspective brief prior to the session. The panel then listens to the arguments, reviews the perspective brief. This is all confidential, just like any other type of dispute resolution form. And then the panel will take a moment behind closed doors, confer, and then come back with recommendations. It's non-binding. It's a way for parties to kind of hear from the court and what may or may not happen. And then they have an opportunity to phase into mediation. Then the session may convert from neutral evaluation to mediation. So we're excited about trying that. That's something way back in Lake County that I tried a couple times, and I know other courts have done it and it's been successful. So we're excited to see how that rolls out. Agreement Express is for individuals who want to put an agreement on the record, whether it's simple, they need to change residential parent for school. We get a lot of those this time of year, late in the summer, or parties who want to come in and put an agreement on the record. That can be done in conjunction with one of the forms of neutral evaluation or mediation. Then we also have informal proceedings, if you're unfamiliar. That's simply voluntary mediation. It's closed cases, and one party may contact the court that they want to do an informal on a parenting matter, and as long as the other party is willing, and again, the case would be properly screened, just whether it's appropriate. We're also going to have those cases during settlement week.
And those will be only, the informal proceedings will be like how we always do those. Those will be done through family court services. So those will only be family court services mediations, if you want to call it that.
And I believe, in case you're like, this is a lot of information, if you are participating in those programs, you will receive something that is written up that will tell you what to do as a neutral evaluator, as a mediator, and as participants. Is that correct?
Correct.
Next slide.
Yes.
If you're in neutral evaluation, is somebody else going to be sitting with you, like somebody from family court or?
Yes, it's a panel. So a panel typically of 2, could be 3. One of the individuals is the individual who's trained in not only neutral evaluation, but also trained in mediation. And the other individual could be a family law professional, could be another.
In the case I had, it seems like there's a lot of, they haven't documented light of it. And there's a lot of issues right now regarding the children and me. I mean, I don't think I'm capable of solving those. I mean, my theory is, well, that's what the GAL recommended, you know, that's generally what I'm thinking.
Well, we can discuss after in the specific case, but the perspective brief narrows down what the issues are. So the issues could be, and I don't know without looking at a particular case, but it could be financial, it could be parenting. The perspective brief would narrow that down for the panel.
Find out who else is on the panel. Can you get there?
No, that's information that I have for, if you are one of our outside mediators or evaluators, I can provide you with that information after our session right now. Good question. All right, general information about settlement week. So we are going to have rolling emails starting on Monday, the 20th, for all participants in settlement week, to give parties a reminder of their sessions coming up, what do they need to bring, what are the expectations, where the check-in. So look for that, council. You should be getting those informational emails if the session starts on Monday the 27th. You should get your email on Monday the 20th, and then so on and so forth. So on a rolling basis. We will have a check-in table on the second floor. So if you are checking in as an attorney on a case, check in once your parties have arrived. We anticipate probably about 40 or so people Monday morning, so trying to just make sure we manage the logistics. Go ahead and check in once your party has arrived to let us know that you're here. Then you will be directed which floor to go to for your session. We'll have sessions on 2nd, 3rd, and 4th floor, and you'll find that out once you check in. If you are an outside evaluator or mediator, please come here to the ceremonial courtroom where we are today to check in, and we'll give you your information. I can also provide information to you right after the session today, so you know a little more about going into it on the day of your session.
So the Attorney Lounge is also going to be open. Many of you know where that is, just right around the corner. And then I think, Judge Cook, you want to talk about those last few things on there.
So yeah, the attorney lounge will be available. There will be some snicky snackies there. We'll cover some, have some, maybe some lunchtime stuff, because you know, when you get hangry, it's hard for you to actually do the work. So we want to leave you with some stuff there. That is not for the parties themselves. There'll be something up on the 3rd floor, but we don't want, we don't want to rumble, in the attorney lounge, because we don't have security there. So we want them up on 3 and 4 when we have eyes on them. So we do have community agencies available. So I think we have a couple people here today representing them. I think I saw somebody from CSEA. So thank you so much. So we're going to be able to get worksheets for you, like child support worksheets that you could work with all the mediators. So we'll have some real-time information for you available. So that'll be great. We'll also have, for some of those agreements that people come in with, they'll be able to do a check to see whether or not these agreements are good, whether or not there's any kind of coercive control or any DV between the parties, and somebody's getting bullied into, for example, giving up $15,000 worth of arrearages, which I've seen before. So that's why we have child support here. So we're really excited. And we are also going to have Marie Morris here from Community Legal Aid. She will be here also for different hours during the week. So if we have pro se parties that need help, with their forms or whatever else, we do have Community Legal Aid here. And if anybody has volunteered as to help the pro se parties with their paperwork, you guys are basically going to do the catch-all if, for example, Community Legal Aid is conflicted out, or if maybe these people make too much money and you can't help them, and Community Legal Aid can't help them with the forms. So we also will have victim assistance here, which I'm really excited about in case anybody feels like they're, that they need to talk to somebody about a CPO or that they have concerns about their safety.
So with these two tables on second and third floor, if this is a little fast-paced and you can't remember something from today and you have a question, you can go to one of those tables on the second or third floor and they can help you figure out or at least get you to talk to the right person.
Yeah. Oh, the other thing is that the quiet room will be available on a first come, first served basis. For those of you that don't know, it got opened last year. We actually have furniture in there now. We're so excited, and it's wallpapered and painted. And we even have a dimmer switch, so if somebody either needs it for nursing or breastfeeding, or they sort of need their own timeout because the anxiety level's getting too high, you do check in with court security. They'll provide a key, and they get an hour at a time. It's only for one party at a time and their support people. That's in case anybody needs it. So I just want to let you know if somebody's sort of having some issues, let them know about the quiet space. Of course, childcare will be available. We did talk to victims assistance. I know for sure that they're going to be here Friday morning. If the parties call ahead of time, they're going to, you just need to call, if you have parties who are like, I have a problem with childcare, it's the middle of the summer, let them know about the child watch room. But it's really better to call ahead of time to make sure that you've got a place reserved, okay?
My suggestion would be to tell any of your clients to try to get care in advance because there's a chance that may not be available depending if someone else has called. And so although it could be, I would hate for them to rely on that and then not have it available and then they don't want to engage.
We will be, remember, this week we will be handling civil protection orders, okay? So those will be going on during the week anyhow.
Well, check-in procedure. So check-in is going to be on the second floor. As we previously mentioned, I believe it's in your notes. I believe all mediators and neutral evaluators are asked to be here 30 minutes in advance of their session, 15 minutes for parties or any participants in the actual session. But the ones that are running the session are asking to be here a half an hour in advance. As Magistrate King said, counsel will check in for both themselves and their clients. If your clients arrive before you, they will just be asked to take a seat. And then once you get there, you'll check them in. If you arrive without your clients, then you'll take a seat and wait for your clients before you check everybody in. Of course, if there's no counsel, unrepresented folks will check themselves in. And then you can also confer privately with assigned rooms that you would ask your mediator and evaluator. Do you want to talk about the assigned rooms?
No, you'll get your rooms. One is a primary room. I believe all the magistrates are scheduled. The one room is the primary room, which will be their courtroom, and then the other room will be the other room that's more for caucusing and breakouts. So if you need another room, let us know. We'll probably be able to find one.
All right, so before coming to mediation or informal proceedings, all parties should have completed their agreement to mediate. That's our settlement week form 6A that is located on the website in case your client tells you they haven't completed it, as well as the summary of issues, which is form B. The agreement to mediate, they can also sign here, but we're really working hard to make sure that individuals have signed that prior to the actual day. But just in case, they do need to sign it before the mediation proceeds. Summary of issues is very important. We're getting those back right now from individuals, and they're going in the confidential mediation file, so they are not to be filed, but they narrow things down so our mediators know what is exactly needs to be talked about and tried to resolve at the session. Again, that's something that can be completed the morning of, but better if your client completes it with your assistance prior to the session. There's also,
Where do we send those summary of issues and agreements we need?
that's a great question. The second floor, Family Court Services, Attention Settlement Week. I believe the email is fcs@drcourt.org.
And the email's on the last slide.
Oh, okay.
So we're under questions. So it's on that last slide. Yes.
Family Court Services. And you can always drop it off at the second floor too, if you're happen to be here, but it can be emailed to Family Court Services prior to.
The idea is that, so there was an initial referral, but, you know, from the time of the referral to the time of settlement week, you know, lots of things can happen and change with families. And so that summary of the issues is almost like a catch-all. Like maybe you resolve one thing, or maybe something blows up. This is the time to sort of like give us a heads up as far as what what do we really need to concentrate on? You have to concentrate on with your mediator. The other thing is that lots of times, you might have a pro se party on the other side. We may not get all the information, all the forms that we're needing to. That's the reason for the half hour before. Check in, look through your stuff. Ryan will be there too to make sure. I'm going to be around, and we'll be making sure, we'll have out what hasn't been signed off on or done yet. You know what I mean? So just understand there might be things that we want to get finished up, in that time. That's why we say the half hour for the mediators, neutral evaluators, and 15 minutes for attorneys with their clients. Get all that kind of paperwork finished up so we can be good to go on time.
Every case that has been accepted into settlement week for mediation will have an order to mediate. That order to mediate will state the date and time of the mediation, as well as who the mediator is, and then any requested documents that the parties need to bring. The mediation is only going to be as valuable as the information that the parties bring into it. So I would definitely have a look at that, advise your clients what they should be bringing to the mediation. For pending divorces, and maybe the judges want to speak to this individually, there's a specific judge's order for divorce that will be filed after the order to mediate.
So I believe those went out. I think they went out on the 30th, or I think they went out on the 30th or somewhere around that. So you should have already received those orders. And these are for all pre-decree divorces, but if you have a spousal support issue that you're mediating on a post-decree, I would still suggest you follow some of those things. However, for the pre-decree divorces, if you haven't seen that order, be sure to read through that order. I think the most important part, and we'll talk about it in another slide here, is that even if you come up with an agreement, you still have to have a final hearing on that. So the suggestion in that order is bring your laptops. If you have proposed documents, you might be able to edit them. We will also have those Supreme Court forms or the court's forms based off of the Supreme Court forms that will allow you to fill out decrees, parenting, shared parenting plans, and separation agreements.
I will be here on divorce cases, so if you guys have all your paperwork, let's get it done, okay? So I want to get it on the record, and I'll get my bailiff to, put in just make sure that we have a special place for you, and we will make sure we put it on the record that day, okay?
And the last one.
So if you are a mediator, you'll be completing a memorandum of understanding if there is an agreement. We've broken it down into 3 different ones. The idea is to make it very simple and easy. It's a checklist. So we have one for parenting issues. Did they agree to shared parenting? Did they agree to parenting plan? What's the schedule going to look like? For financials, again, another checklist in terms of division of assets, debts, property, allocation of same, and then C is for child support. So we have a separate one for child support. What is the order? Is there a deviation? Why is there a deviation? So it should be very easy for the mediator to get the parties in counsel what the agreement is. Then the next step would have to be completed to actually finalize that. But really important to make sure everybody's on the same page as they walk out the door. What is it that we just agreed to, right, to narrow things down? So that memorandum of understanding will be available, and we'll have that on the day and prior to and on the day of your session.
I think it's also going to be emailed in that final email before their session so they can get acclimated to the form. So you'll get that also in advance to review.
And just dumb question of the day, a memorandum of understanding is not binding, so if, when the lawyers get involved and things need to be adjusted or whatever. Okay.
Well,
That's a
so
great
there's a few
question.
ways, we'll talk about that in a second, but there's a few ways that can be handled.
Great.
Because we were aware of that as well.
All right, is that me?
That's you.
All right, so for the procedures for neutral evaluation, I mentioned the perspective brief. That should be completed at least 2 weeks prior. So that means this week. If they haven't done it already, parties counsel, they need to complete. We have one form for financials, one for parenting. Just a point of reference, these are the same forms the Ohio Supreme Court uses. So we do have those available on our court's website. It is a comprehensive form, so please go over that with your clients and make sure that's filled out. These are not to be filed. They are to drop off at Family Court Services or emailed for inclusion in our settlement week file for that case. And as soon as the neutral evaluation is over, those prospective briefs are destroyed. So don't worry about those getting into the wrong hands. We will make sure to keep them confidential and to get rid of them after. Each party will have 15 minutes to present their argument to the panel. Then the evaluators will confer privately, as I mentioned earlier, for about 20 or 30 minutes.
I'm just going to stop you there because it looks like, I mean, I did the training, so it looks like we missed a step. So each party will have 15 minutes. That means the party themselves. The idea here is I call it the pre-gaming the trial, right? So a lot of times we have parties that they just want their day in court. This is a great way for them to do it. And then you, as you know, the practitioner or opposing party can then see how good are these people as far as testifying. So they will have the 15 minutes. However, after that, each attorney, you know, if you represent, you know, the plaintiff, you got about 5. So sort of flip that idea. But they sort of get a free-for-all and understand if you are a neutral evaluator, you can ask questions during that 15-minute time period so you can understand what exactly are we talking about and where are they getting to. But I just wanted to point that out.
Judge, from a timing standpoint, is this like the Court of Appeals, where it's 15 minutes, including questions that come from the neutral evaluators?
Yes.
Yeah.
Yeah, because we want to make sure we give enough time afterwards to see if we can get to, like, you know, them to then digest what they just heard from the neutral evaluators, you know, go out and talk to their attorneys about it, come back, where are we at, you know what I mean? And if we don't give enough time for that afterwards, then what's the point? You know, you guys walk out and you're like, you know, is that just what happened to me, you know?
And we should mention each session, whether mediation or neutral evaluation, is scheduled for a 3-hour block. So 9 to 12 in the morning, 1 to 4 in the afternoon. So with the idea, even if you don't use all the time, at the end of the session, that may be a good chance to try to at least narrow down what the issues are. But in looking at the initial 10, 15 minutes is for the neutral evaluators to explain the process and what the expectations are. Then you have another half an hour of argument, 15 minutes both sides. Then the evaluators take a couple minutes privately. So that already puts us maybe into an hour and a half. So you're halfway through before coming back in. So that's why that timeline looks like that. And if parties counsel need another session, that's just going to be subject to availability. So that's something that we can cross that bridge when we come to it. But again, for the first initial settlement week, we'll see how things go in terms of the sessions.
And we asked, the judges aren't allowed to know what happens in the neutral eval. And part of the screening process was to ensure that no one involved in these processes were either the judge or the magistrate that presides over the case. So I believe that you told us the only way we would know is if they asked us to know and both parties agreed.
If they had an agreement, so they moved from neutral evaluation into a mediation phase and they came to an agreement, and at that time, if they waived that confidentiality to put agreement on the record, that's how it would work.
I'm trying to ask, if we're doing the neutral evaluation phase and mediation, they come to a full agreement. We do an MOU then, or?
Any agreement with the mediators should do an MOU. And I think once everybody sees the MOU, it's very simple, a checklist. So you should be able to accomplish that quickly after the session.
Is that me?
Do you want me to talk about agreements?
Sure.
Okay, so we will have magistrates on hand to confirm agreements and stipulations. We have all the forms for all this. We have forms like the MOU. We have forms for stipulations. We even have the stipulations even have checklists. So, they're like granular, they're down by topic. And so we just got those done today. And so, like it says that myself and Magistrate Heinbach can confirm any final agreements for divorces. And, Judge HiRes got Magistrate Ford and Magistrate Kinney. I will say that, so if you see the agreed entry of stipulations will be available. All these forms are going to be here as far as a hard copy also, right? So it's just like when I do Justice Bus and Paul has them all, by whatever it is. So we're just going to have a big bin. If you need it, we'll have it for you. If you want to work on your computers, you can. But it'll all be here for it. And we will also have, of course, whatever, our local forms that we've, amended the Supreme Court forms because they, were deficient. And so we have our own forms that you can have it. I don't know if you want to talk about, so Agreement Express, chances are, those are probably going to be people that are pro se, and chances are you guys aren't going to really have anybody that does that. But I think about Agreement Express, it's like a drive-through, right? It just, if you didn't get it scheduled, but something came up and it's a school issue, come on in, let's get it done. This is the week to get it done. So we do have people on standby to handle that. And same thing with the stipulations.
Are you having them file the motion on the proposed agreements expressed?
I don't think so.
Okay, I thought we talked about that.
Well, I mean, we'll talk about that. Okay. See, once again, like I said.
So with the agreed entry, to answer your question, Attorney Black, with the agreed entry of stipulations, I printed them out. You guys can't really see them from here, but we have agreed entry of stipulations, which is just a generic form. If you come to an agreement, you can agree to the terms of the MOU. You can either agree and attach the MOU, and at that time, when you're ready to put it on the record, you've stipulated to what's in this document. But we've also broken it down with there's an agreed entry of stipulations just for child support cases, as well as one for financials in divorce cases and one for parenting. So if you have a divorce case that has both financials and parenting, you would do the parenting and the financials before you went to go put that on the record. We highly recommend, though, if you have a finalization, you can do it this way, but you can also use those court forms that we're talking about or have those pre-typed. And then finally, once you sign this, stipulations by law can be filed. So once you agree and you stipulate, if your confirmation hearing isn't happening that week, or you have a partial agreement, you can put the stipulations on these forms, you sign it, your client sign it, it gets filed, and then we hold you to it later. So I hope that makes sense.
And as we know, all agreements reached in mediation are subject to attorney approval. So certainly clients go back to their attorneys, confer. The idea is to, at least if they're walking out the door, if there's something they stipulate to, if their agreement's reached, then put it on the record. I think that is helpful. Then the attorneys can go and draft what they need to do in terms of paperwork, whether that's a shared parenting plan, separation agreement. So that's our hope anyway, that you can cross that bridge and put the agreement on the record that day. And we've tried to make it somewhat simple in doing that with the designated.
Now, I will say that I want to make sure we talk about, we checked with the Supreme Court. You can use the MOU forms in the courtroom. However, the way it was explained to us was that if you have a mediation and both parties are like, yeah, okay, we agree to it, but we want to put it on the record, don't sign it with the mediator. See if you can get us, like a confirmation hearing or, in front of, like, we can actually get it up on the record in front of a judicial officer, go in the courtroom, that's where you're going to sign it, right? Because then it becomes something else. It becomes something that's on the record that we can just do here. Then the questions can be asked and we can make sure that we get all the information that we need and that it's on the record. And so now it's changed from an MOU with the mediator and now it becomes, part of a stipulation, whatever you want. And remember, sometimes you're not going to resolve the whole thing. Stipulations are for what can you resolve. If you can resolve, 5 things out of 7, hey, that's 5 things out of 7. Get it on the record as soon as you can, and that way we only have 2 issues left for the court to handle. So, it's still a success if you can get, a partial resolution.
To clarify those confirmation hearings, for anything that is not a pre-divorce case, there will be magistrates available. If you have a resolution, let your mediator know. They can check in on the 2nd or 3rd floor with one of the tables, who will then try to find someone to put that confirmation on the record. For the divorce cases, that's what Judge Cook was talking about. If they're pre-decree divorce, you would talk to, you still go to the tables, but it would be either her or Magistrate Heimbaugh. And for my cases, it would be Magistrate Ford or Magistrate Kinney, as I won't be here this week. But just keep in mind that you may have to wait for that person to be available, and that they should get you on the record within that 3-hour window. But we do have other people who may be confirming things, and we have so many magistrates that are mediating that we have people available. We might have to just wait just a little bit for them. So just keep in mind and be aware of that.
But it'll be worth the wait. Okay. You want to talk about checkout or do you?
I'll talk about checkout. So everyone will check out on the 3rd floor. So check-in is on the 2nd, checkout is on the 3rd floor. The mediator, neutral evaluator will take everybody to the 3rd floor, and they will let that person know, did we resolve? What's the outcome? Do we need a confirmation hearing? Here's where we are. They don't want a confirmation hearing. Here's the MOU. So at that point in time, the mediator will complete the outcome report and then pass all of that on to the person on the 3rd floor. There's an exit survey, and that all participants, that's the mediators, neutral evaluators, and clients or pro se folks, they will all complete that exit survey while their check-in process is being done. So they'll have a seat on the 3rd floor, there will be a QR code, and they will do that exit survey. And then after they've done that and confirmed it's done, then they're free to leave. And if you want another second session, ask at that table to see if there's availability.
And if you think that you're chugging along, you're like, wow, there's just way more information, but we'd really like to do a session in the afternoon and just keep going, then, the sooner you realize that, the sooner let us know on the 3rd floor, and we can see what kind of accommodations we can do for you, okay? We tried as much as we could to not schedule, mediators and magistrates, 2 different mediation sessions, or, 2 different neutral evaluation sessions in the same day, to hopefully give them a little bit of time, or give them some time in the afternoon to handle if a mediation would go over. So we'll see how it goes.
And I think with the CSEA cases, Magistrate Heimbaugh and Magistrate Ford are going to be handling some of those. So again, just be patient, because we have to make sure that we can get a magistrate available to you if that's one of the cases you have. We're trying to identify those ahead of time so that we know which cases might have to involve one of those magistrates to confirm or put on the record. The next is the question slide. Did you have anything else you wanted to say before?
No.
Magistrate King?
No? Okay. So that's a good question. That's one of those issues that was looked at in terms of the screen. There is a debate in the mediation field about having a guardian attend if they haven't completed the substantial portion of their investigation. So the cases were looked at in terms of what was the referral. Did the referral mention that the guardian should attend? If the referral was silent, and has that guardian completed a substantial amount of his or her work? And if so, then they could potentially attend. So I know we have some guardians scheduled and some who are not scheduled. So it could be a parenting case, maybe it's pretty new. The guardian was just appointed, so the guardian, it's not necessary to attend. Or if there's a guardian on it, but the issues are really the financial issues, then the guardian wouldn't attend. But if you are a guardian on a case, then if you are supposed to be at the settlement week mediation or neutral evaluation, you would have been notified and scheduled.
But I would, no problem, asking the guardian ad litem, like, where are you at now? I mean, like, when we scheduled it, it could have been May. It's now July, and the end of July. Things change once again, you know what I mean? So let us know. I also don't like to have, I'm not a big fan of making people wait around. So I think that if you're a guardian ad litem, in this case, you know, you're mediating, you know, the mediator has a case that has both parenting issues and financial issues, you know, see, you know, okay, instead of making a guardian ad litem be there the whole 3 hours, well, you know, see what, you know, like, see which should go first, and then maybe work it out between yourselves. Okay, so we're more than willing to do that. Yes.
What happens if somebody doesn't show? I don't mean by somebody, I don't mean a party. Like one of the professionals, like one of the lawyers, guardian ad litem. Does it still go forward? Does it get canceled? Like what happens?
It's a good question.
Probably the same thing that happens, I mean, it's a court order, right? And so there are some people who were ordered to be here who didn't want to be here. So it's a court order, and I guess we would just treat that as we would a court appearance where somebody doesn't show. So you would think a professional is going to show at all of their court appearances. I just assume we'd probably call them, find out where they are, and kind of go from there. But it is a court order. Just 1 second. I just wanted to address.
But I will say that, though, that, you know, the orders do say, if you didn't show up, I believe you have to pay a certain fee, just as much as if, you know, we were doing mediations for parenting cases. I think it's like $100 fee or something. So normally we waive the fee, but your failure to appear, your party's failure to appear, they will then be assessed that fee. So that's a good way of getting people to show up. So that's one of the things that we'll, you know, of course, it's already in our orders. That's one of the things that we'll be imposing. I mean, hopefully we won't have to do it. But if somebody's sick or whatever, you know, I mean, if you know for some reason, like you're an attorney and you have a party who, like, that day of or whatever, the sooner you let us know the better.
Attorney Stats, to address one of the issues that you said, I think if you are a guardian on a case and there's counsel, maybe send an email to the counsel saying that you could be available if they need you by phone, but you don't plan on attending unless they tell you otherwise. I'd still communicate that, because that time that you would be there, if you just decided to show up, would still be on the party. So I would make that suggestion.
We could do it by Zoom too for the guardian items if they can't make the whole session.
Attorney Grasky.
Was wondering, I thought I understood that these programs are actually voluntarily entered into by parties?
No.
No.
One of the biggest problems was it was not voluntary.
So I will tell you, right, so I will tell you, when I made the referrals, I had conversations on all my cases with attorneys on it. It was pro se parties, I had conversations. I did the referrals with them as much as I could, and we discussed it. It wasn't a, you know what I mean, like people were like, you know, coming in kicking and screaming. So I did get the buy-in already, you know, at the referral stage, but you never know. Maybe the attorney thinks it's a good idea, but their client hasn't figured it out, right? And so that's, you know, that in itself is a process about, right, but and also by actually being here and seeing what it's like. Because some people don't understand that, you know, when you get to be in control of your own like decisions and you get to actually have choices and you get to have input, that it's way better than a judge issuing a decision after hearing a day-long trial about your entire life. That's right, yeah, please, you know, make me the bad guy, I'm used to it.
I think I did the same. I mean, I know I did the same thing on my cases. I know some of the magistrates referred. I'm not sure. I think for the majority of these cases, we did talk to the folks ahead of time, and some requested it. But the issue is that the parties may start to complain to the lawyers that they do not want to attend. And at that time, we've already issued the court order. They've gone through the program, and they need to attend. So, you know, they Google everything else. Tell them to Google what mediation looks like, and they'll be prepared when they come in. But it is a requirement if the order's been issued. Yeah.
And I'd just like to address briefly, because I know our family court services are getting some of these, that attorneys or unrepresented parties are calling saying, we have an agreement, so we're not going to attend. So we're still rolling along that you're attending unless there's actually a proposed agreed judgment entry that's been submitted and the judge or magistrate says this is acceptable. So until we see that piece of paper or paperwork, it still is being thought of that it's doing the settlement week.
Right, and so on a divorce case, of course, we have to do the final hearing, and I know I do have to deal with pro se parties that think that they can just have me sign it without them present. It's like, I'd won at Justice Bus, it was a lot of fun. Poor Charles' buddy was volunteering, he was like, what's going on? But, so the idea is that, you know, if you actually resolve it ahead of time, I will, I will bust hump to find a space during my time, my docket before settlement week to, have that final hearing. But if you say, hey, we've got it resolved, then, but you haven't gotten the paperwork, then you've got to show up for settlement week. You come to your session and we'll put it on the record at that time. Hey, we'll do that too, but we just want to finish them up. If you come during settlement week, it'll actually be good for our numbers.
So we included here the email address for FCS. We know questions will come up. You'll think about it. We printed these out so that you can refer to the slides. But you can always send a question to fcs@drcourt.org, and maybe at some point in time, if Paul can, maybe we'll send something out to everyone do you have any other questions a week prior to, so that you can ask the questions and have them answered. We're just trying to avoid people either not being aware of the process or having to keep going to the tables to ask questions. So definitely keep this email and email those questions, and you should be able to get an answer before you show up.
Any other questions? Wow.
Okay, then.
All right. Well, there's pizza outside if you didn't get it yet. Thank you. Thanks for attending. Short notice, I know.
I know.